May it please the Honorable Court, for the record, TST Procedural is my name. I appear on behalf of the first accused person in this matter.
May it please the court, my name is Mpofu. I appear with Mr. A. Mukia for the second accused, who will be joined by Mr. G. Stoller in due court. A.
Are we ready to proceed?
The state is ready.
Yes, my Lord, we wanted to seek guidance and directions from this Honorable Court. You will note, my Lord, that the accused persons filed their application for referral, and the state then also responded to the application. From the state's response, it appears that there are some issues, some facts that are not in contestation, yes, and other facts that are in contestation. Our proposed course of action was to then lead evidence so that the facts that are in contest can be determined on. You will also note that some of the facts that are in contestation relate to the age of the learned assessors in this matter. So we wanted directions from the court in view of that, given that the court had indicated initially when we once appeared that the age of the assessors could be disclosed. So we wanted to get directions from the court as regards to the age of the assessors, whether or not they can be requested to disclose it, or whether or not we have to subpoena the registrar of this honorable court to disclose that issue, because we also note that the state has put in issue that aspect. The other housekeeping issue that we had related to, I had a chance to have a conversation with my brother, Mr. Mabaud, who indicated that they were abandoning the points in the minute that they had raised. And we also wanted maybe for, as a housekeeping issue, to have directions from the court in respect of subpoenaing some of the witnesses that would need to lead evidence on in respect of the other issues that are in contestation.
Yes, you have said what may be in contestation would be the age of the assessors.
Yes.
What else?
There is the age of the assessors. Then one other aspect that is in contestation relates to whether or not the members of the Zimbabwe Anti-Corruption Commission were interfering with the proceedings at the magistrates' court, and whether or not there is protection afforded to the accused person, whether or not there has been selective prosecution. That is the other aspect as well that is in contestation.
You want to lead evidence to prove interference, like in proceedings in the magistrate court.
Yes.
And you want to lead evidence that there has been selective prosecution.
That would be all, my lord.
The proceedings in the magistrate court have already terminated. They were terminated.
Indeed.
And you have a record of proceedings in the magistrate court. You want to rely on that?
Indeed, on other aspects, we will just submit the record of proceedings. But there are other aspects that relate to issues which transpired outside the record of proceedings. For example, my lord, the issue that related to the consent to bail, which had been granted to the accused person, which was then revoked at the instance of the chairperson of SAC.
Were those submissions not made in the court, in the magistrate court, at the time of making the bail application?
They were related to, yes, my lord.
So they would obviously be on record. They would obviously be on record.
The majority of it will be on record.
Yes. Yes, so there would be the court can always relate to the record, can refer to it. Is there anything else that would require proof? I also noticed that some of the issues raised relate to judgments, and judgments don't need to be proved. We can always refer to them. We can read to them.
Indeed, my lord, judgments do not need us to read any evidence in respect of that.
So, it may not be, unless the state is of a different opinion. I know that in the application of the request for referral, there's no, the accused persons did not mention the ages of the assessors. Maybe it's because you wanted to, but depending upon the state's attitude to that, is it not something that you can quickly ascertain so that we don't have to delay proceedings by leading evidence on things that can be ascertained?
Indeed, my lord. Maybe if we could be given an opportunity to...
How much time would you need?
I think
to confer with the state. Well, just before we make a decision on that, can I hear the state?
My Lord, the state is no longer pursuing the point in the meaning that it had raised with the court.
Yes, thank you. Yes, and as regards the issue of the ages of the assessors, would you require proof to be laid, or it's something that can easily be ascertained from the registrar?
It could be ascertained from the registrar, yes, if there was a provision for the disclosure of the ages of assessors.
If there was
a provision to for the assessors to disclose their age. I don't know what provision my learned colleagues are proceeding in terms of, which compel the members of the bench to disclose their ages.
Well, I suppose what only needs to be ascertained is whether they are above 70. They don't have to tell us, their exact ages, so that we then deal with that dispute. If there's, in other words, the court would want to know whether there's a dispute of fact regarding whether they are above 70. We don't need to disclose their actual ages, but the issue is whether or not they are above 70.
I'm sure the state will be.
I suggest that I could perhaps afford you a few minutes, maybe 5 or 6 minutes, but not more than 10, and then we can proceed.
I'm sure
and there won't be any need to lead any evidence. Yes. But just before we take the break, you can see that I'm sitting alone. It is because I understand that while assessors need not be excused when these issues, but they don't have any contribution to make. And in terms of the High Court Act, the judges can excuse them at the hearing. Would there be anything wrong with issues of law being dealt with the judge presiding alone?
The state is not objecting to the judges.
Mr. Tretero?
We have no issues.
Mr. Madu?
We have no issues.
Very well. So when we reconvene, I'll be sitting alone, and I will have proceeded in terms of Section 11, subsection 2 of the High Court Act. Since we are concerned with legal issues, I'll be sitting alone. Yes, I will therefore afford the parties a break of about up to 7 minutes. All I need is for you to agree, to ascertain whether the assessors are above 70. It's not really necessary then to disclose what their ages are. Okay. The court will adjourn briefly.
Yes, my lord. We have managed to establish that fact that both the assessors are above the age of 70, my lord. We have also further then engaged and we have agreed that with that we have streamlined the agreed facts. And we have also agreed that in terms of the rules, the proposed course of action is that we must now file a statement of agreed facts, from which then we can then make the application. Room 108 of the Constitutional Court rules, of the High Court rules. Let's go with me, my lord. Sub-rule 4, my lord, is read with Rule 24 of the Concord rules.
Is that not necessary when the decision to refer is made? As far as we at this stage, as I'm sure you submitted in your request for referral, the facts that you said were common cause. And the only issue that in your view required evidence was the ages of the sister, and that has been resolved. So there's no dispute of fact is doing. The facts upon which you are basing the application are known. If then I accede to the request and proceed to referral, then obviously there may be need to prepare for the purposes of presenting your argument, I don't see any difficulty in proceeding.
Well, my lord, the point that we were putting across was that in terms of the law, this court must make a finding on the facts, and those facts can be presented either in the form of affidavit or in the form of oral evidence or in the form of a statement of agreed facts. The document that we had filed on behalf of the applicants was a request, but it was not evidence.
But the facts are not contested?
Yes, the facts are not contested.
So, it's just a question of regurgitating what you have already presented, which is not disputed by the state.
Indeed, my lord, the facts are not contested.
You actually presented them under the survey, the facts that are not disputed. And the state has confirmed that the facts are not disputed. So you need to...
If you could just wait.
They are disputing some of the facts.
Yes, my lord. I'm reminded by my brother that they are disputing some of the facts in quotation.
Which facts are those?
The issue of interference.
We said we'll go by the record.
Yes, my lord. I indicated that we could go by the way of the record of proceedings.
That is correct on record. Do you have any difficulties with proceeding straight away?
We would not have any difficulties, my lord. If you could just
And how are you going to proceed? You will be making submissions on behalf of the first accused.
No, the two accused persons had made a joint application, my lord. So we had agreed that if we were to proceed, some issues were going to be dealt with by Professor Matuku, some are going to be dealt with by myself, some...
Yes, who is going to begin?
If you could just... Yes, so Mr. Matuku would start.
You start. Thank you.
Before I start, my lord, I wanted clarity from the state because our understanding is that they are not necessarily in agreement with everything that we have placed on record, especially those issues that are disputed regarding what transpired in the magistrate's court. So that needs it to be very clear what it is that they are not, that they are accepting. And Mr. Mabaud, in our discussions with him, he appears to be taking issue with some of the facts that have been put across. Perhaps he could confirm in open
Sorry, is the accuracy of the record in the magistrate court disputed?
What we wanted, perhaps the court could guide us differently. We wanted to be sure that that record which is on file, we actually make sure that what is on file, what is on record is agreed as to what it is that constitutes the basis. We are saying so because of the Constitutional Court's attitude, which is even where, in the event that we succeed in getting a referral, they might say that the referral was not proper because they say to themselves that they always ask, was this a proper referral? So on behalf of the accused persons, we would respectively ask the court to allow that process of being agreed, what are the agreed issues. We have said from the comment that we've given, my lord, that perhaps this is at the point of referral. But our understanding is that it has to be ascertained first, whether or not you are going to grant the application for referral. But the factual issues must be agreed and clear.
These are not issues that we ought to have attended to. don't really appear in court to say that you need time to prepare. I think these are the issues you would have attended to. Although I'm not following in terms of if you are going to rely on the record of proceedings, it's entirely up to you to pick on those sections of the record that your clients want to rely on. But nobody should be able to change it. We are just going to, you are saying that you are going to rely on the record of what transpired in the magistrate court. And the record of the magistrate court will be the record of what transpired. Unless somebody is disputing the accuracy of the correctness of that record. In terms of what you pick to support the request for a referral, it's entirely up to you. Maybe let me hear from the state.
My Lord, before that, I wanted to say that perhaps when you hear from the state, if I may both help to the court, I might give the example of what we've done with the assessors. We established the fact that they are above 70. On the basis of that established fact that they are above 70, we build our legal argument, a request for referral. So we want to do it in respect of all. We establish what is the fact, and then on the basis of the fact, we make our referral request because we build our questions on that basis. That is what when we came, Mr. Jetro, when he stood at the beginning, he said he was seeking directions. To be clear, we thought that today's first hearing, first session would be to get that direction. We didn't get enough time with the state. I must say that it's very difficult until the time that we have then agreed that we could go and ascertain the ages of the. I wouldn't say that it was easy for the lawyers here to say what is it that we agreed. We really wanted a statement of agreed facts put before, so we know this is agreed as a fact. And what is the legal request that we are making? That's all we wanted to get. So if we shouldn't make submissions. We wanted to make submissions on the law rather than submissions on the facts.
I noticed this is to show that constitutional issues that arose in the magistrate court, they are expected to be found in the record of proceedings that came from the magistrate court. This court cannot then be made to sit to hear factual issues in relation of issues that had in the magistrate court, because if it arose in the magistrate court, now coming to the high court, those issues should be on the record. This is not a magistrate court to sit over issues that happened in the magistrate court. So, if this issue was raised in the magistrate court, I think the record will suffice. It should be in the record of proceedings. The issue would have been raised initially in the magistrate court. That is what constitutional precedent has said. That one cannot raise issues in a superior court. Issues that we are supposed to raise to be raised in the magistrate court. So what my very colleagues intend to do, I think it is not what is expected of them by precedent. So they cannot go using the backdoor to try to raise issues that they should have raised in the magistrate court, then raise them in the high court. So the state is in agreement with the court's directive that the record of proceedings from the magistrate court would suffice if they indeed had opined that there was a constitutional issue which they were supposed to raise at that time. And therefore, the fact that they want to call witnesses over things that happened in the magistrate court, I don't think that would be the proper procedure that they intend to adopt. That is all my
Wait, yes, it's not.
Yes, my lord. I hear what he's saying. Perhaps he has not, with respect, understood where we're coming from. We have no problem. We are ready to begin, my lord. The problem is we do not have that record. Our understanding was that with the IECMS system, we need to upload that record, the one that we are relying on. We cannot argue on the basis of a record which is not on record. I think that if I may adopt that language. For now, what is on record would be, I think the procedure is the charge and then the defense outline. That's my understanding of what the record is before the court at the moment. I'm not sure what else is on the record. We thought that when we discussed with our learned friend outside that we were going to, now that the statement of agreed facts may be overtaken by events, we wanted to file that documentation which constitutes the factual basis. So whichever way we begin, we would need to, we can go with the fact that we rely on the record that took place in the magistrate court, but we just have to upload it. We just have to,
yes,
that has to be made
uploaded later. Obviously, you will be arguing these issues in a certain order, and maybe during the tea break, I don't know what time it is now, you will be able to upload, so you can perhaps dwell on those other issues. Then we can deal with that later.
If the court may bear with me to just lay a specific. My lord, if we may ask to be allowed then to make presentations on the basis of what is on record and which is now agreed is the age of the assessments. That one is established. Yes. So we can make submissions on that, and then if the court allows.
There's also the issue of live streaming. I think it was.
Yes, that could be.
So maybe we could start with the issue of the constitution of the court itself, the issue of assessments.
Yes. That we can proceed. Now, we would require that we deal with that first, because that would be the statement of agreement. Thank you, my lord. I will start on that aspect. We seek a referral of a question that we've put as question number 1, which is whether or not the fact that there is no maximum age limit stipulated in Section 6 of the High Court Act is contrary to the constitutional maximum limit that is provided for judges of the court. By the Constitution, which is the 70-year maximum limit for judges of the court, whether that is an infringement of Section 69, subsection 2 of the Constitution, and also whether it is an infringement of Section 56, subsection 1 of the Constitution. We have put those questions as 3 questions that arise from the mere fact that the composition of the court as it sits now would have 2 members that are over 17. My lord, the submission that we make is that the section of the High Court Act which does not stipulate a maximum age limit is unconstitutional. The basis for that arises from an interpretation of the maximum age limit that is given in the Constitution. Although the Constitution does not say that that maximum age limit applies to assessors, it imposes a maximum age limit for judges of the court. Now, how do we interpret that provision? That is the issue that we wish to be referred. The principle of interpretation that is adopted in this country is the principle that is set out in section 331 of the Constitution, as read with section 46 of the Constitution. Section 331 of the Constitution, as read with section 46 of the Constitution, which says that in interpreting a constitution, the primary focus must be on the purpose of the provisions. And that in looking at the purpose of the provisions, you also take into account the need to promote and respect the rights that are set out in the Bill of Rights. So I would say with respect that it is a purposive approach. Now the recommended standard is that you adopt 2 stages if one wants to ascertain whether or not the provisions of the statute are constitutional. We start by looking at the provision of the statute that we are attacking and give it a meaning. And then we see whether that meaning is consistent with the meaning we would give to the Constitution. So our starting point is section 6 of the High Court Act, which does not impose an age limit on assessors. The literal interpretation is that any person can be an assessor, and that any person above the age of 70 can be an assessor. So the High Court Act above 70 can be an assessor. That's what it means, section 6. It doesn't impose an age limit. And as it has happened already, the court, as it currently constituted, the assessors we have are over 70. That is permitted by section 6 of the High Court Act. It is that permitting which we are challenging, because assessors are permitted by section 6 to be above 70. That permitting, my Lord, means that the High Court Act has a situation where a judge who cannot be above 70 by constitutional stipulation sits side by side with persons who are above the age of 70. In other words, the High Court Act permits a person who is older than the age that cannot be crossed for the judicial officer who is presiding to be sitting as an assessor. We want to submit that if the provisions on judges are interpreted purposefully with a view to achieving their purpose, they mean a very simple thing. No person can preside over the High Court and make judicial decisions if they are above 70. Can you repeat that? The Constitution, properly interpreted and interpreted for the purpose that it wishes to achieve, is that no person who is above the age of 70 can sit as a member of the High Court bench and make judicial decisions. That is our reading of the Constitution. In prohibiting a judge who is above 70 to sit, the Constitution is saying a very simple thing. You cannot determine judicial issues at the High Court level if you are above 70. Now, although the word used in the Constitution that it appears in the section dealing with judges, the word judge must be given not a literal interpretation. Simply means a presiding officer. Simply means a member of the High Court. My Lord, that is our interpretation, and that is the interpretation that we wish to put before the Constitutional Court. And it's based exclusively on principles of interpretation. And the authority that we wish to refer the court to is the case of In re Meso, 1994. Sorry. I said the case of In re Meso is 1994. I think Warren to Zimbabwe law because it will be page 54. I'm not sure whether that, if that is not correct, we will correct that reference. Page 54. That case is authority for the view that a constitution is not just like any other statute. It must be interpreted broadly so that when one reads it, it would not be correct in our submission for a person to say it just refers to judges. It refers to every presiding officer. The Constitution does not provide for assessors. It is the legislature that has expanded the concept of who should preside over the High Court. So assessors are introduced by the legislature. And our contention is that when the legislature introduces persons to sit with the judges, it is bound by the constitutional principle that the persons it is aiding to judges must not be above 70. That is our contention, my Lord. The Constitution prescribes for judges and judicial officers and puts an age limit. The legislature comes around, adds other people to the bench, and doesn't put an age limit. The legislature would have faltered. So if the Constitution had itself provided for assessors, it would certainly have imposed an age limit of 7 years. That's our contention. Now, there is a principle which is very clear that in matters of fact, which is a principle that is in the High Court Act, in matters of fact, assessors have the same voice as the judge. And there are cases where if they disagree, the two assessors can override a judge on findings of fact. So you have situations where the judge is in the minority and matters of fact are determined by assessors. The registrar of the High Court, we respected what the court indicated. We didn't ask how old exactly the assessors were, about 70. But let's assume that an assessor is 90 years, because the High Court allows, the High Court Act allows. So you have two 90-year-olds disagreeing with a 58-year-old on a very critical matter of fact. And these matters of fact relate to critical issues. In a criminal court, the actors rears and the mens rea are key issues there. Sometimes we have to find, was there an intention? And whether there was an intention or no intention is a matter of fact. It's a very complicated aspect. It will require what we now know, circumstantial evidence, the drawing of inferences. And why the Constitution says at age 70 you stop is because the High Court has serious responsibilities which include findings of fact. It will be contrary to any reading of that Constitution if we walk out of this court and say that the Constitution prohibits a judge from reaching 70, but it permits assessors to go beyond. That will be clearly contrary to the Constitution in our reading. So it's a principle of the Constitution which we extract from section 186, subsection 5 of the Constitution, the one that imposes an age limit. So we want that question referred to the Constitutional Court. I have not gone, my Lord, into the details of why these age limits are imposed. But it's clear that in the reading of the Constitution, The role of a judicial officer at this level is a very active one. It requires someone who is alert throughout the trial. Trials can be very long, we know that. And the state of affairs where you are in court and half the court is asleep must be avoided. The Constitution doesn't like that. It knows what happens to people who are above 70. I'm not saying that that's what they do, but it's a very active work, my lord, and it is clear that our reading of the Constitution is that it does not permit that. That's the point we are making. Now, if I want to just close on that point, if we may go with that. Yes, my lord, I wanted just to wind up on the argument because at this stage, all I am required to demonstrate is that this issue is not frivolous. It's neither frivolous nor vexatious. And that what section 186, subsection 5 of the Constitution stands for is a principle. That's what we are saying, it's a principle. So there's an age limit of 70, and then other provisions there's an age limit of 75 if subject to good health. A person is a judge of the Supreme Court or Constitutional Court, you don't automatically go beyond 70. You have to satisfy the Judicial Service Commission and the President that from 70 to 75 you are fit and proper. That these provisions are quite clear in section 186. So our submission is that those provisions must be seen as constitutional principles. They must not be seen as just isolated provisions which are just restricted to a person who is a judge. And I think that the argument that we have from Mr. Mpofu is just to come and say assessors are not judges. And the Constitution is referring to judges. And so where are you coming from? That's the point that we are here to make. It's not about the name judge. It's about the principle that a presiding officer of a superior court must not exceed a particular age. The legislature must not be permitted to sidetrack that, to undermine that principle by bringing in people who can actually simply do the work of judges when they are above 70. Because the finding of fact is clearly a very important judicial function to determine what the facts are. So that's the point we are making. We are not then going to get into the issues that relate to the interpretation. We will leave it to the court to adopt the principles of interpretation. But this is not for this court to do. It is for the Constitutional Court. What this court must ask itself is that, is the referral of such a question a frivolous or vexatious? Now these terms have been defined by the Constitutional Court. And the leading case is at Martin versus Attorney General. And the case of, I'm sure we've cited those cases yes, we've cited those cases now. Martin versus Attorney General. We've also cited the case of Williams and another versus Misipa. And then the case of Jonathan Spanda versus the state, and a lot of other cases. I want to say to the court with all respect, your task is very simple. Very simple. Is this frivolous? What I would say? That surely I think citizens of this country are entitled to say, is their constitution permitting such a state of affairs where you can have over 70 sitting side by side? That is a question that has to be resolved. We were not able to get a judgment of this court, but I need to say for the record that we understand that there was a judgment at one time by Justice Chitabu. I'm not sure, my own friend is now here. He might then please assist us and give us some notes. We were looking for a judgment previously by Justice Chitabu, which had upheld this point. And then the referral to the Constitutional Court, according to what we have been told, is that it didn't kick off on technical issues relating to how the referral was made. We would be able to provide the court with that aspect if we really get the correct facts, but this appears to have been the case. I'm saying it to go to the question of is it frivolous or vexatious. It might keep coming. It has been raised before. It will keep coming. And that this court must not look at the accused persons who have raised it. It was going to be raised. It will be raised. It has happened to be raised by the accused persons who are before you, my lord. But that question must be referred to the Constitutional Court for determination. Does the Constitution permit such as? If the Constitution does not permit, then constituting such a court and trying the accused persons will undermine their rights. Section 69, the right to a fair trial, they are being tried by a court which is not permitted by the Constitution. Section 56, they are subjected to an unequal treatment because other persons will be tried by people who are below 7. We also don't know how the register constitutes the assessors. So that will also undermine the right to Section 56 of the Constitution. Those were my three submissions. My little friends will add. Yes.
Was this issue raised with the registrar who appoints assessors?
The issue relating to the age.
Your client's concern about the assessors that have been appointed to deal with this matter.
Thank you, Madam, for that question. I will be clear on that. As a matter of fact, we didn't raise it. We didn't raise it with the registrar. We didn't know who was going to be assessors. We only knew who they were. In fact, we were told by the court who they were, but we were able to see when they walked in that they were certainly above 7. We didn't raise it with the registrar. We didn't know before. But even if we had known before, we would have realized that the High Court Act permitted the registrar to appoint persons above 7. So we still have not taken issue with the registrar. We would have taken issue with the court here. In other words, it's not a matter that can be rectified by complaining in respect of each assessor. In other words, my understanding of what the state might want to say from the reading what they've written, they might want to say that we have a remedy, and that remedy lies in us checking the age of every person who comes. In other words, we keep the High Court Act as it is to permit people above 70 to be assessors. Then we just say, I don't like this. But we will not be allowed to say, I do not want this assessor because they are above 70. That wouldn't be a basis for objecting to an assessor if the Act allows it. That is my answer, my lord, to the question that it was not raised with the registrar, and we will respectively submit that that issue must not stand in the way of a referral. It will not make this request frivolous. The request is still not a frivolous. It is neither also a vexatious request, but that the registrar is within her powers or his powers to appoint any person above age 7, as long as there is no finding that the Constitution does not permit it.
So in essence, the accused persons are objecting to the assessors.
My Lord, they are not objecting to the assessors. They are objecting to a legal provision which is contrary to the Constitution, which has then permitted those assessors to be there. Their objection is to Section 6 of the High Court Act, which is unconstitutional. That's the objection that they want to refer to. And it is that section which allows the assessors. The assessors have not committed any wrong in themselves. It's not their fault that they are sitting. They are committed Zimbabweans who want to do their work. Our point is that the Constitution does not commit what they want to do. But we have no issues.
I understand that. They've got their own approach, which is the reason why they are making this request. We have already said that it should not be right for the judge to be framed by 90-year-olds sleeping all the way through the proceedings. I mean, that's basically their reason. That's the apprehension they have, isn't it? And for that reason, they are objecting to the assessors who were assigned to the case.
My Lord, I need to come in and explain that, because that, with respect, is not their problem. The issue with the accused person is that they have a constitution which says you shall not be tried by a person who is above 70. That is what they say. The constitution of this country says that if there is going to be a court in the High Court sitting, no over 70 must sit there. Then they are now being tried, and over 70 are sitting there.
I know, I appreciate it, I hear that very well. So, that is their reason.
That's the reason. Their reason is to vindicate
I'm
the
not
country.
really considering my reason, but in essence, they are objecting to the assessments. Their reason, apprehension. They don't.
The point that they are not objecting to the assessor, they are objecting to an unconstitutional. It's not a court that is permitted by the Constitution. And that is why they want this issue referred to the Constitutional Court. But I cannot, even if the registrar will say, for you, I'm going to look for 45-year-olds. That will not take away their constitution.
Persons below or age like 45, would they still be raising the complaint?
For them now, it can no longer happen because the trial has started. That's it for the court.
Which says if at any stage an assessor becomes incapacitated or unable to proceed. In other words, there appears to be a provision on it.
And now is we've raised a constitutional issue on the basis of the composition of the court. It's our characterization of it. We would be entitled to have the matter referred to the Constitutional Court, then whether this is a frivolous issue or whether it's vexatious.
That's exactly what I'm saying. Where the act that you are challenging provides for it.
But it's no longer possible for this court to deal with the matter other than the way it is, because the court is already constituted and the trial has already started. The accused persons had their charges read, they pleaded, they filed their, in fact, read their defense action. So we are already in the trial. And that provision would not avail. My understanding of the provision is if there is an inability, we haven't said that they are unable. We have simply said that it is unconstitutional for them to sit contrary to the Constitution. Just to keep directing our presentation to the fact that what we are attacking and what we are seeking to be referred to the Constitutional Court is Section 6 of the High Court Act. So that concerns, that will then take away Section 6. Section 6 must not remain on the statute book as its current stands. And it is arising because it has already caused itself damage. In the sense that if we were to reconstitute, whatever will happen, it will be completely not permitted by the Constitution.
Yes. Are you saying that the court can be reconstructed? What is possible in terms of the High Court Act? The court will be reconstructed in order to deal with the complaints raised by the accused person. I mean, this particular issue.
Thank you, my lord. Not at all. The court can be reconstituted to deal with non-constitutional issues. But once a constitutional issue has been raised, because it has already arisen, when we are on one-way traffic, we just have to deal with the referral. And my submission, my lord, is that at this stage, the court just has to decide whether this request is frivolous or vexatious. If it is not, the court is hence, if I may put it, tied. We have already made the request for referral, and the Constitution guides the court as to what it must do. It must ask itself. In fact, it must refer unless it reaches the conclusion that the request is merely frivolous or vexatious. It's a very uncomfortable situation in the sense that whether the court likes it or not, it has to refer this matter unless the court says it's frivolous. But there is no frivolity, because if there are any suggestions as to how to proceed, those suggestions are coming after the event. So they cannot be used to determine frivolity, because frivolity is at the time that we raised this issue. Is it frivolous or vexatious? That's my submission, madam.
I'm asking you this because in terms of the section 6 issue, in the first section, there is a challenge the assessor, which probably is object, and not providing. I mean, there's no obligation to give reasons. And once an assessor is challenged, my reading is that the assessor, whether one up to should step down or recuse themselves.
Yes, my lord, that section must be given an interpretation which is consistent with our principles of interpretation. The principles of interpretation that words are given their ordinary grammatical meaning, unless doing so leads to an absurdity, or it will be an absurdity to just challenge an assessor for a reason that is lawful. So that will be absurd. That is not the intention of the lawmaker. You can only challenge an assessor on a basis of an unlawful. Say they are biased, or you think you can't say, look, you come from Machebeleland, and I don't want you here. That cannot be permitted.
Is there anything wrong with that?
Yes,
because the accused person does not need to provide a reason. In other words, if he feels that he just doesn't like the assessor to preside, or there are two assessors to preside because they come from Machebeleland, that's entirely up to him. It doesn't have to be a reason which convinces the court. The law entitles him to object to two assessors at most. And when such assessors have been objected to, for good reason, or objective assessed, or for a bad reason, objective assessed, such assessors must step down. So it's only, you want to take the matter further, but I'm saying for the first assessors, the accused persons are entitled to object for any reason which they keep to themselves. And the law obliges the assessors to step down.
My lord, I would respectfully say the submission we are making is that that provision cannot be read to mean that any reason will prevail. You can only object for a lawful reason. That's the submission I'm making. And that the interpretation that must be given to that provision is that the objection, although you don't have to say it must be a lawful one. So if you were to base it on the basis of age, that would be unlawful. Because it will be unlawful under the High Court Act. The High Court Act permits any person to be an assessor. And then in the example we have just unfortunately given, you cannot then say you come from, like I've given, that's what came to my mind. You're coming from...
I know you just gave that as an example, but I'm simply saying that for the purposes of subsection 4, the reason is, in my view, neither here nor there. It's irrelevant. It's entirely up to the accused person to challenge the assessors. He's under no obligation. If there's no reason, there is is no, the court is not empowered to, consider whether or not the reason is reasonable. It doesn't have to be given. So, whether it's lawful or unlawful would not arise, because the accused person does not have to be.
Perhaps I give two answers, my Lord, just to keep on that issue. First, if we must take into account the situation where an accused person, if we go by that interpretation, can object to every assessor who is coming. So every
yes, up to 2. Yes, up to 2. That's my understanding. It says 1 up to 2. So beyond that, then perhaps there might be need to justify. But for one assessor, up to 2, I think it's very clear, it's unambiguous. The accused person may just stand up and say, I'm challenging the assessors.
Yes, but that is where our problem comes from, my Lord. They may why up to 2? If then the next assessor who is coming is still over 70, then there's a time when this right is exhausted. In the other words, you have done your enough objections, and then you get someone that you do not like because they are permitted by the Act. Our point is that is why there ought to be a referral. Because you can do it in perpetuity. You say, okay, age, and then the next up to, as the provision I'm now reading it, clearly that not more than 2% is chosen to be assessed.
Yes, but it's a remedy that's available to them. Why are they not utilizing it?
It cannot be utilized now because they have no control as to who comes. Most of my Lord, it does not resolve the issue that we have put before the court. What we seek, Section 6 of the High Court Act, in not giving an age limit, is unconstitutional. That's the section that we want to refer to. The other issues coming in would be, we are objecting to the fact that Section 6 of the Constitution permits an unconstitutional sitting of the High Court. That's the issue. And that cannot be resolved by whatever is going to be done in this particular trial.
No, I'm raising this because we are getting criminal trial. And my understanding is that we need to resolve, to deal with constitutional issues. In this case, by welfare, which are standing in the way of the criminal trial. But if there's a solution, at the very least, which can deal with the complaint, are you requesting a referral in the public interest, or because it is relevant to this trial?
My Lord, it will not resolve the issue. Because what the provision does is that you may object to not more than 2 persons. And if we were to go with that, it would mean that the accused persons are given a right to object to the 2 persons that are currently sitting.
Yes.
And then what happens next is that there will be other assessors will be put in their place.
Doesn't change anything. They can still object if there's a valid reason. Well, my understanding is that let us forget about the age. Maybe it's another issue. They have objected to 2 assessors for the reason that they may think that they are conflicted, which reason they are not required to disclose in the law. Naturally, the registrar has to appoint assessors to replace them. The registrar might still appoint assessors who are conflicted. They can still object. But at that stage now, they will be expected to give reasons. So at this stage, we're at a stage where the law makes it very simple. Just object to the assessors who have been appointed. You are not obliged to give them reasons. The law is a remedy. If, for example, the registrar then appoints assessors whom they may be willing to object to for another reason, then they still object. I don't think that they are bad from doing so. I'm saying this because, as I said, I do not have before me an application in terms of the constitutional application, because That's what section 1751. Yes, I do not have that. I'm here to deal with the criminal trial. So if there is any issue which concerns the accused person, which can be dealt with in terms of the law, so that the trial progresses, then we deal with it in accordance with the remedy that the law provides.
My Lord, if you may bear with me just 1 second to... Thank you, my Lord. I wanted just to make sure that as a team we are clear on the answer to the question that you are posing. We respect that the issue you are raising goes to the question of whether or not the raising of this question is frivolous or vexatious.
Yes.
So we have two answers to that question. The first one relates to the observation or the exchange that the court says we are sitting here as a criminal, you're sitting as a criminal court, you have a criminal trial to attend to, and then there might be constitutional issues that are rising. We respectively submit that in terms of section 175, subsection 4 of the Constitution, it doesn't matter what sort of proceedings we are before. If the constitutional issues arises in any proceedings, so even where a criminal trial has started or is about to start, a constitutional issue can be raised and a referral sought. So that point we respectively say is answered by the Constitution, section 175, subsection 4. We would also wish to respectively emphasize, my Lord, that it shouldn't matter that it is a criminal trial. Our worry is that the Constitution is aware that there are various proceedings, but it never makes a distinction between criminal proceedings or civil proceedings. As long as a constitutional issue has arisen, and this constitutional issue has arisen by virtue of the composition of the court. The trial is to start, and it has already started, and then the accused persons realize that their right is being infringed. Then secondly, we insist with respect that it is section 6 of the High Court Act which is at stake in not providing a maximum age limit. It must not continue to exist because that is the cause of the problem that we are facing. Then finally, we have the right that the court has pointed to, which is section 6, subsection 4 of the High Court Act. It does provide a right, but the accused persons cannot be forced to proceed in terms of section 6, subsection 4, when they also have a right that they are given by the Constitution, section 175, subsection 4. So this court cannot say to the accused persons, yes, we know that the Constitution allows you to raise a constitutional issue, but you should do that. They don't believe that section 6, subsection 4 provides an effective remedy to the unconstitutional existence of section 6. Like the example I've given you, my Lord, that it can then be done every time, up to a maximum of 2. There is a suggestion that if another reconstitution comes in, the accused persons objects again, and so on. That should, as far as we are concerned, of course, only arises if the objection is lawful. But as long as the objection relates to something that is there in the law, you cannot object under section 6, subsection 4. I'm not sure whether I have addressed the concerns of the court. The point being that as long as section 6 permits a person above 70 to sit in court, and in this case, this court, as we sit at the moment, only that they have been excused for this particular hearing. We already have people who are above 70. It's already unconstitutional as far as the accused persons are concerned. They want that referred to the constitutional court.
In other words, the accused persons do not want to utilize the remedy they are given to them because they prefer that the constitutional issue be dealt with.
Yes, I'll answer that, but I also want to ask my learned friend, Mrs. Chole, to just help me with one aspect, if the court so permits. The point that we are making, my Lord, perhaps that's the area of departure we want to keep making it. They are not objecting against assessors. That's the point that we're making. We may be right or wrong, but our point of departure is that this is not an objection to assessors. It's an objection to the composition of the court.
Are they not objecting to the two assessors?
Not at all, my Lord, and we wish to be.
They are happy with them proceeding. In other words, what I'm saying is that they are not objecting to assessors in general. Nobody is. But the accused persons have got objections to the assessors who were appointed by the registrar to be part of the bench dealing with the criminals. So they are objecting to these assessors who have been appointed. I'm under no illusion, unless I'm misunderstanding. We are dealing with particular assessors who are part of this court, who were appointed in terms of by the registrar. But we are dealing with specific assessors, not assessors in general. So that's exactly. Unless I misunderstood the issue that's concerning the crime.
Yes, I'll just simply repeat that as with respect, it will not be a correct characterization of the objection. The characterization of the objection, we are objecting to the composition of the court, which has over 70s sitting there when the constitution does not permit it. That they then happen to be assessors, a different issue. And then, so we then realize that the problem emanated from Section 6 of the High Court Act.
And who are over 70?
They happen to be assessors. But that is the issue that we are dealing with. My Lord, if you characterize it that way, then it will not be the characterization given by the accused. That is number one. Number two, even if that characterization were to be taken, the accused persons have a right to raise a constitutional issue that they cannot be forced to go through Section 6, subsection 4. That's the answer. But I want my learned friend, if the court so permits, just to add a point.
Mr. Story.
Thank you, my Lord. My Lord, I stand with the position advanced by Mr. Matu. Our challenge really is on the validity of Section 6. It's not really to object to the assessors themselves. But to answer his lordship directly as to why Section 6 subsection 4 cannot be a basis for avoidance of the constitutional issue that we raise. You would note, my Lord, at page 3 of the referral that we found, in particular paragraph D, we then speak to certain events which then happened a day after the commencement of the proceedings, which is the reconstitution of the court or recomposition by the substitution of an assessor. Now, and we cannot proceed in terms of Section 6, subsection 4 for the reason that once there's been a recomposition or a substitution of an assessor without the consent of either the state and the accused persons as they sit in the dock, that is an infraction on their right to a fair trial. And that cannot be resolved by saying object to the new assessor, because we are already saying certain events have taken place during the proceedings as they are occurring. So I just thought we should clarify that issue. That
is that quite correct, Mr. Story? Yes, indeed. When we said that we had an assessor who failed in, but the proceedings really had not started, in the sense that the person did not plead. When we came to convene the proceedings in earnest, that's when I advised the parties that the other assessor failed in, and so that we don't delay the commencement of the trial, we have asked the registrar to appoint. So at that very stage, we were still managing the case. We had not reached a stage where proceedings had commenced.
We hear him, Lord. It maybe becomes an issue of interpretation as to when did trial proceedings commence against
I
my.
to say that when the accused person is
In the Lord, there is also then this issue. On the day when the first assessor was eventually substituted, there were proceedings before a court which had two assessors, which had called upon the accused persons for trial. So there were two assessors, which the accused persons appeared before it together with the court. One of the assessors, due to his incapacity, which is then contemplated by Section 8, as you say, fell ill. He was substituted. And our contention really in terms of the facts is whether we were in a trial or we were in proceedings before two assessors and a judge. To substitute that assessor, the court required the consent of the state and the accused persons. And that is why we cannot appeal such an issue and we cannot review it in the Supreme Court because we do not approach the Supreme Court as a court of review for first instance. It becomes an infraction on the right of the accused persons to a fair trial. So that then fits into that constitutional issue to say, whereas one might suggest that go by way of Section 6, subsection 4, and object to the substituted assessor. We cannot because from how we perceive the fact, this is already encroached on our right to a fair trial. It becomes issues with a lot of characterization, as Mr. Maduvi is saying. Are we saying when we set for case management, those proceedings are not proceedings contemplated by Section 1754 of the Constitution? I submit not. So that's why we cannot resort to subsidiarity or to say for the notion of avoidance. It can only be addressed by way of a referral. And our point, Lord, is that it's not
correct, Mr. Stolle, that the court, or perhaps the judge, did not solicit your attitude. If I remember very well, I advised you that the assessor had fallen ill, and we thought we did not want to delay the commencement of the proceedings, and we asked that the assessor be substituted before the proceedings. And I asked him, would you have any problems with the state? And there were no problems.
We know that the record shall reflect there were objections started by Mr. Chicheng himself, and he said in addressing those issues with Mr. Matuku, we shall relate to the constitutional issues that we raised.
Yes, there were objections to the age, not to the arrangement that the trial progresses before the minister. And I'm saying, yes, you cannot say that the court did not. I don't believe that there was any issue regarding the propriety of the trial. The only issue that I was with respect to the age of the offences. This is a new issue that you.
I know that here with respect to differ on one thing, maybe the record, the transcript, will show us the accurate position. But I recall Mr. Matuku seeking to advance the basis of our objections as part of the constitutional issues to be raised. And notwithstanding the.
So what is the point? Are you saying that you're now raising the issue that the appointment of an assessor to replace the one you call the is constitutional, or is it a new issue that you're raising?
No, it's not a new issue, it's already placed before.
Yes, but what is the significance with regards to Section 6.4?
The significance is that we cannot resort to Section 6, subsection 4 on account of those events and how they happened and,
how do they impact?
And the issues raised.
The accused persons are the only issue with respect to Section 6, subsection 4 is that the accused person is entitled, just like the prosecutor, to object to up to true assessors. And the events that you're talking about, how do they affect that? And that's what I want to understand.
My Lord, we have placed before the court a referral application which already contains that particular issue about the answer to whether we objected to the substitution of an assessor or not. The transcript will show that we never gave a negative or positive answer because we said that issue will be addressed in the issues that we intend to raise before the court. And this issue is answering to that issue whether it was resolved or not, the issue of the objection. But we are saying section 6, subsection 4 does not say where there has been a substitution of an assessor in terms of section 8 without the consent. And this is the accused person. They said they were never consulted. They were advised that there's been substitution. But that advice never said we are going to do this or intend to proceed like this. What is your attitude? So we were informed. That is basically what happened. But they are saying section 6 does not then take away the right to raise a constitutional issue to question the substitution of an assessor. Because the question might be, or the answer would be, if you raise or you are challenging how an assessor was substituted, are you not at liberty to invoke section 6, subsection 4? And we are saying we will not go that route. We do not prefer to go that route because this is now a constitutional issue which has moved to say I'm in trouble. I've been told you object or not, but this is what I've discovered, that someone has to check the assessor in proceedings. Yes. And I'm entitled to raise that issue by way of 175.
How does it become a constitutional issue? What I'm saying is that I'm getting to know now that the accused persons are objecting to the substitution of the assessor. What does it become? Because we deal with that. We deal with that objection. If it is the objection now that you are raising, we deal with it. But it's separate from the issue for referral.
My Lord, if you go through the application in courts, page 3, paragraph T, it's a list before the court. We go to
that, Mr. Stone. We are still dealing with the age limit. If you are going to allude to that, it will be when we get to it. You see, all I'm saying is that I thought we were rising to make additions on the issue of the age. Now this is a separate issue, which you can then wait and raise at the appropriate time.
Yes. Maybe I'll put it this way. I was alluding to that factor so that the court understands that we cannot rely on section 6, subsection 4 because of the things which have then happened in respect of the assessors.
But also you motivate that. But as of now, do you have anything to add with regards to the age limit?
Beyond what Mr. Matuku has said, we gladly abide by it. If I may discuss.
There's another.
I wanted
How
to be sure that
we deal with this? Do you want us to dispose of this issue, or you are going to motivate all the constitutional issues?
I think we might need to deal with the issue of the age. The one that we've just motivated for now, so that they respond to it and we find
and you rise again to motivate the other issue.
We are saying that we believe that, for example, if the court were to with us on that issue, it will still resolve a number of issues. I'm not sure whether we need to get through the others.
I thought that maybe we'll just deal with all the constitutional issues. They may all succeed, one may succeed, but we are at a stage when we are dealing with referral. And so it just happens that we have sought referral of a number of constitutional issues, but at the end of the day, we're just dealing with referral.
Yeah,
so
as
you can motivate the other constitutional issues.
As the court places. So I will defer to my learned friend.
There is the issue live stream, which was also raised.
Indeed, my lord, we addressed the issue of live streaming. Mr. Chimombe will address that particular aspect.
Thank you, Mr. Chair.
My Lord,
What paragraph is it in the request?
my Lord, it's paragraph E, page 3 of 20. Paragraph E, page 20, it is also then related to
Okay, you can read it so that we all follow.
Lord. Lord, how the issue has been put across is whether or not the accused person's right to a fair trial and right to protection and benefit of the law as enshrined in the Constitution are, and I will move for an amendment to read or are infringed by the decision of the learned judge to allow trial proceedings to be broadcast live or live streamed on various media platforms, considering that the determination was arrived at without the participation and consent of the state and the accused persons. My Lord, how the issue is proposed to be couched would also appear in CCZ4, which is attached to the application itself. CCZ4, the form that accompanies the referral application, which appears from page 12 to 13. Yes, from page 4, that is the CCZ4, referral constitutional matter form. The constitutional issues proposed to be referred, but then that issue appears at page 13 as paragraph 4. It is crystallized in that manner. My Lord, as we make this point, we also seek the court to indulge us in at times lack of the full contextual facts as to what would have happened, because some of these things we were just informed that this is what has happened. The matter was supposed to commence, I think, at 11 for trial on the second day, if I'm not mistaken. And then there was that delay where we were informed that the delay has been occasioned because the court was entertaining, I would say, an application or a request. They've been entertaining a request from the various media platforms that they be able to live stream these present proceedings. When we want to presume, but also try not to speculate where that request was being entertained, whether in chambers or not, we wouldn't know. But one thing that is factual is that the state and the accused persons were not in attendance when that entertainment was happening. But so that I don't speak on behalf of the state because they might be happy with the outcome of events. Speaking in particular emphasis to the accused persons, then that the accused persons or their lawyers were present to air out their views on the request that had been made. And the point really that we make, Lord, is that approval, whether it was by way of an application or request, to have the media live stream or broadcast this proceeding would amount to a violation of the accused person's right to a fair trial, in that their views were also not considered before the request had been granted. They had every right to be heard before such a determination could be made. Our departing material rule so sacrosanct in this jurisdiction. It only does not amount to an infraction on their right to a fair trial. The right to be protected by the law. They are interested parties, the accused persons. It's their trial, their fate, and their families who are at the risk of losing their loved ones due to incarceration if there's a conviction. So these accused persons, facing such a case of magnitude, allegations raised against them, they ought to have been heard before the request was granted or refused. My Lord, I do not wish to belabor the point. This position is found by the Constitutional Court in Chamisa versus Mnangagwa, CC 42, Chamisa versus Mnangagwa, and 24 others, CCZ 42 of 2018. Lord, you will note that in that judgment, there had been an application or a request for the media to broadcast the electoral petition proceedings. And the Chief Justice said to order a case management where that issue had to be dealt with in detail extensively by all the parties. There had to be, Chamisa had to be heard, Mr. Mnangagwa, the President of Zimbabwe, had to be heard, and all other stakeholders who were involved in that matter. Such that it resulted in a judgment of this court which deals with that issue. And in the Constitutional Court accepts that whereas court proceedings are public proceedings, the point which it emphasizes is that broadcasting live, and I submitted in the extension, live streaming, is prohibited by law, unless special circumstances exist where the court has been petitioned to then allow the broadcasting of the media or of the proceedings. And that is the point that we make, that once we have the Constitutional Court found on that issue and what has then transpired in these proceedings, we submit that without affording the accused persons an opportunity to make extensive submissions on whether they wanted these proceedings publicized by way of live streaming, or they would have actually preferred maybe to apply that proceedings beyond in camera, without having afforded them an opportunity to make their representations, that violates their constitutional right. And we submit that that is an issue which is not frivolous nor vexatious. It has to be referred in our humble submission, Lord, to the Constitutional Court for determination. My Lord, it's an issue again which we have no redress in terms of avoidance. Is there anyhow which can be addressed? We submit not. As I have already indicated, and I submit to the Lord, we cannot petition the Supreme Court to say there was a determination or a ruling or a judgment because we don't know what happened as far as that these persons are concerned. So we have nothing to take up on appeal. We have nothing to take up on review because, as I have already said, the Supreme Court does not attend reviews petitioned by parties. It does so mero motu. So under those circumstances, the only appropriate remedy is the constitutional remedy that we seek to enforce. And lastly, my Lord, we want the media to understand. We do not raise this point because we want to get the media, but we believe that in as much as accused persons are being tried in a matter which is of public interest, whether it's in public of importance or not, it's something else people can debate about. But that the public are interested in following these proceedings. Our issue is that the accused persons have the right to be heard before their fate is determined by way of a live public trial. Lord, apart from that, we stick with what Chamisa versus Mnangagwa says. The Constitutional Court goes to town extensively dealing with this issue from other jurisdictions, and we believe this is the locus classicus that deals with the present circumstances that the accused persons find themselves in.
So, you were saying that the accused persons ought to the matter ought to be subject to case management.
Case management and possibly a hearing, because in the Constitutional Court that's what they did. Case management to call the parties and then
So,
extensive
in this case,
submission.
what transpired, I recall that I notified the parties that there has been a request by the media to live stream the proceedings, and that it was considered that the matter was in the public interest. I remember using that word, and that I thought I had agreed that it was in the public interest, and that we were adjourning until 2:30 for the logistics of the setting up. Did the accused persons object through you? Live stream?
Lord, we were never given an opportunity to object. We were again advised that this is what has happened and this is what I have.
No, you were advised of the decision by the court. And were you precluded from objecting in the usual manner? In other words, from notifying the court between, I don't remember what time it was, but maybe mid-morning and 2:30, either by way of approaching the judge in chambers, or even, saying so in court, that we are concerned about exceeding that. Well, definitely it was not an application as couched. It was just a request. I disclosed that I had accepted the request, but still it was not immediately implemented. You know too well that when you are not happy, you are entirely within your constitutional right, as you say, to notify the court of the consent, and then the matter will be dealt with. I'm just saying, that opportunity was there. I only got to know in this referral that I don't know whether the accused persons are objecting to live streaming. It's not very clear to me whether they're objecting, they don't want the proceedings to live stream, which is a matter that can be determined. But I am just asking whether the accused persons were precluded from registering their concerns with the court or the judge in the chambers.
Lord, it's how things developed to the best of my recollection. We were advised of, or you notified us of that development, and then court adjourned so that the court would be set up for purposes of that particular issue. So the answer is also that at that particular time there was no objection raised because we didn't have the opportunity to do so, as well as get instruction from our...
What I'm simply saying is that there was a lapse of time from mid-morning to 2:30, and you know as much as I do that you are entitled to approach the judge in chambers if you have any issues concerning that. I'm saying this because a question, this would arise if you had registered your consent and the court had declined to consent. The reason why, it just so happens that sometimes we do things in chambers, but there's nothing really preventing the court from interacting with you in court. Because, as you say, proceedings can be in chambers or can be in court, and they are open proceedings. So it was my considered view that I must announce in an open forum that this is the situation. And your clients were at liberty to say, even straight away, and at that stage they were not being live streamed, that they do not wish it. Like I'm saying, I'm not sure whether the question is that the accused persons do not wish the proceedings to be live streamed, or that the court was not supposed to accept the request without. But anyway, what is the effect on them? I'm just saying there was maybe the court considered and disclosed its inclination. But that doesn't mean that before the decision is implemented. This is not a ruling. I did not receive a court application. In fact, in terms of the matter that we have cited, there's no need for a court application. But that was disclosed, albeit in an open, but it was disclosed. And your clients have time to give instructions.
Maybe before I fully answer that question, I shall also then have to, because you ask a critical question, what is the attitude? Broadcasting.
Yes.
I will also get further liaisons on my friends. But the issue, my lord, is how the request is granted without the involvement or participation of the accused persons. That is what we submit is something that amounts to violation of their right. That something was requested, which had a bearing on our proceedings are going to turn out. They also have their own reservations and they also have their own perceptions on how the child should be perceived as being fair to them. So their issue is, we can, even if there's no application, but that request, once the court sees that request, we have to be notified and we have to address the court on that issue before the court then makes its pronouncement or its, I would say, judgment, as we have said.
The court is notified.
Yes.
Which it did.
Indeed.
In other words, like I said, there was no application. There was no application to court in which the media or the media house is a party. So there was in fact communication. I'm saying at that stage the proceedings were not being relaxed. And the accused persons through you approached. In fact, they could have said so straight away. Or if you needed instructions later, they could have approached the court chambers before that decision was implemented.
You know, that is where we said we needed to take instruction and advice.
You could have said so.
And not only, you know, some things are not apparent as easier as they are developing in court, where you think this is the remedy, this is the solution, this is it, etc. At times you're actually surprised. This is what is happening. Okay, how shall I deal with this issue in terms of the law? And as you are saying, Lord, the challenge becomes when you receive a notification ex post effect. It's different from when the registrar says the judge wants to see you in chambers, there's a development, and then you notify the parties. But when there's a notification which is accompanied by a decision already given on that issue, parties have to now consider, how do I deal with this decision? Because it's like I'm objecting to a sentence already been given. That is not my remedy. I should appeal if I'm dissatisfied with the sentence. And it also doesn't mean that objecting is the only way of dealing with the issue. If the issue goes to the root of my constitutional rights, I am entitled to raise that issue.
Without raising,
without objecting,
without raising with the judge who may accede to the issue.
No, we cannot do so because we are doing it before the judge who acceded to the request, and we do it by way of this referral. It could have been raised orally below.
So what is the attitude to that?
That is something that we need to really get instruction on. And I need to liaise with my friend because it also, you don't want to appear as if you are taking the point for academic purposes. And then later on we apply for that proceeding beyond the camera. We are not playing games, we take the proceeding seriously, and I need to get what my learned friends' views are and what the accused person's views are on that particular issue. Lord, with your indulgence, my learned friends have suggested that if we could deal with other issues, that is to solicit that position.
Your friend's position is here?
Yes. Let's verify
I thought that the concern would arise from the fact that they already have a position. They are engaged with the live stream. If you are not, as you say, raising it for academic purposes, it would have to be raised because your clients have the position. You see, there will be no infringement if they are able to live stream.
If you may just wait a minute. May I approach the client first? My things are could you indulge us?
Yes, you may.
That's why I said why need a long time on that particular issue, that what then is our attitude. But I will let that issue be told with by Mr. Matu as to what is the final position. What is
My Lord, we noticed that our clients are not unhappy with the media coverage. And in the circumstances, we have to drop that constitutional issue. We will not be able to make a referral of an issue. There would not be an infringement of the right. We were unhappy with the manner in which it happened, but they would want the media process to continue. So the consequence of that is the dropping of that particular issue for referral purposes.
Hello, noted. Based on record that the referral with respect to issue number, is it 4? Yes. I think it's the appropriate time to take the lunch break.
Indeed.
And we meet at 2:30. The court will adjourn.